My name is Dr. Khalid. I'll be the moderator for today's session. Let me take this opportunity to introduce our presenter of the day. He's not actually new to us. He also took us through informed concept on 22nd of February this year. So our presenter of the day, his name is Dr. Bashir Ahmed. He's a medical doctor as well as a lawyer. Currently doing his Master of Medicine in Internal Medicine at Moi University. He also finished medicine and surgery at Kampala International University in 2010 and also Bachelor of Law. So as an LLB in 2022. He also has an interest in medical law as well as nephrology, and previously worked at Aga Khan Hospital. So the topic that he will be dissecting today is medical negligence laws in Kenya, the challenges and opportunities. Welcome, Daktari.
Thank you very much, Dr. Khalid. I also take this opportunity to welcome everybody who is on board today and everybody who is also to join us. Doc, if I'm audible, please let me know so that I just proceed.
Yeah, you're audible enough, Doc. Yeah.
So, thank you very much. I also would like to thank, Octree team for inviting me for the second time to share medical law generally, for the simple reason that law and medicine, there is a relationship. Law and medicine are intertwined. Law affects actually how we practice medicine. Law affects how we discharge our duties as doctors. The other reason is that medical negligence cases are rising in Kenya. There's no adequate, clinical or even literature information as to why medical negligence litigations, litigations are rising in Kenya. And there are several reasons. One could be the population getting access to internet in a way that before every patient comes to the hospital or the clinic, they have already equipped themselves with medical information. The second thing is that it seems the legal fraternity, the lawyers, are slightly ahead of us in terms of doing research and writing academic papers on the subject of medical law. Lawyers have actually written books about medical law. And it seems it is the lawyers and the legal fraternity who are now deciding the standard of care of medicine in Kenya, because they have the literature, they have the information about medical law, and they can decide when to take a doctor or hospital to court. So today, we are discussing medical negligence in general, and then we will, go into the aspects of each of the components of medical law, and then we will see a few case laws outside Kenya and within Kenya. So WHO actually has gone to the extreme aspect by actually even listing medical negligence among the top killers in the world, around the world actually. And they are saying that 1 in 10 admissions leads to adverse events. And they have done actually research in many parts around the world, and they have come to the conclusion that 1 in 300, hospital admissions leads to death, which is avoidable death. This statistics is actually disputed. These statistics I'm putting here today, it's not necessarily, it can be disputed by anybody. But the message I'm passing here is that WHO and many institutions are realizing that medical negligence is rising. And there are some things which can be done to prevent it. And actually it is costly. Around the world, WHO estimates 42 billion US dollars every year spent on issues on medical negligence. But there's also a huge amount of money involved in medical negligence cases. For example, in the US, where medical negligence practice is well established, every year different hospitals ordered by courts, they have to spend close to 800 million US dollars. That is more than 1 billion Kenyan shillings. I mean, more than 100 billion Kenyan shillings to settle down medical negligence issues. And actually in the US, every single claim which is proven in front of the court, it attracts around an average of 550,000 US dollars. That is around 78 million Kenyan shillings. In Kenya, as I was saying earlier, the numbers are really coming up with speed. In 2018, this is actually from Standard News. We'll go into the details of medical law, but just to bring to your attention the importance of medical law and why we should invest in prevention of medical law rather than meeting medical negligence claims in court. Nairobi Women Hospital actually was ordered to pay 54 million Kenyan shillings after normal delivery went wrong. Most of our patients are not really happy to take us to court. They appreciate what we do. And most of our patients and relatives understand that patients have died because they have died because of what has brought them, the condition they had, whether it is dilated cardiomyopathy, which is terminal. However, few cases will end up in court. And these few cases actually, in most cases, will be in civil case. Civil case means that the government is not involved. Can either be tort. Tort means the patient claims that he has been injured by the action or the inaction of the hospital or the doctor. Or they can bring a claim in contract. They can claim that they had a contract with the doctor or the hospital and that contract was broken. In Kenya, as I was telling you, the numbers are coming up. Just in 2019, hospitals, whether they are clinics, whether they are nurseries, other medical facilities, even some county hospitals combined, they had paid more than 500 million Kenyan shillings for various reasons and different periods of time in 2019 to settle down claims in court, and some of them actually to settle down out of court settlements. Please allow me to bring to your attention this Kenyan case law. We don't have to really understand the case law and the legal principles itself, but it's very important to understand the outcome of this case law. PKM, that is the mother of a child who was injured according to that claim in Nairobi Women Hospital on 27th of May 2007. The first plaintiff, that is the mother of the child, she checked into the first defendant's facility, that is Nairobi Women Hospital. And after being attended to by a doctor, she was admitted to labor ward. She was waiting induction, which was actually started. She has attended the same facility several times in the past. And it seems everything has been okay. Once she was admitted, labor was induced. It has failed. But in the process of induction of labor during that period, she has claimed that she was left alone in that room after she was given oxytocin. She has also alleged that the hospital, that is the first defendant, or whoever is working for the hospital, whether they're doctors, nurses, or any other person who was on duty that night, did not monitor her labor with due care and attention. And she was left alone in the delivery room, which according to her was grossly negligent. And she claimed that this caused her severe physical, mental, and psychological anguish. In court, when you are claiming something, if there's no physical injury, in most cases, people will claim damages and compensation on mental and psychological anguish, even if they were not injured. Going on 29th of May, her labor actually had intensified without good progress. She actually took, according to her, matters into her own hand and demanded to see a doctor on call. She says nobody was available. But that afternoon, the gynecologist has arrived. That is the second defendant. The second defendant is now the gynecologist. And the patient was rushed to theater for emergency cesarean section. The procedure was done. A baby was born, JB. The baby has suffered severe birth asphyxia. She was taken to Aga Khan Hospital, admitted to ICU. And the patient was in ICU and HDU for about 3 weeks. It's very important to understand this section because many of you may be familiar with our senior colleague, Professor Kiama Wangai. He's a doctor. He's also a lawyer. He has masters in medicine. And then I don't know whether it is pathology or clinical medicine, internal medicine, but he has masters in medicine, but also he has masters in law. He has acted for many patients several times in the past as an expert witness for them. Professor Kiama Wangai has gone through the history of the patient. He has asked for the file and he has given the court this verdict. He has said, had the labor been monitored, the cesarean section would have been done well before 1 p.m. The baby would have been born healthy. He has even named the doctor who was involved. I picked this one from Kenyan law report in that it happens to be here. That is publicly available information. So Professor Kiama said that Dr. Kagema erroneously indicated that P, that is the patient, had pelvis that could deliver normally. He continued giving the medical expert witness to the court by saying that the nurses did not monitor and or observe the patient as required every 30 minutes, and therefore could not have alerted the doctor that the labor was progressing very well. The condition of the child is now permanent brain damage due to asphyxia, and he has blamed the hospital, saying that it was poor monitoring of labor, and this could have been avoided. You know, this is a really very powerful indictment from a colleague. And if you happen, God forbid, to be who is on the other side in that court, we really stand less chance actually winning that case, because it's a bit a difficult situation. The court actually, in coming to its conclusion in that case, concluded that under the doctrine of vicarious liability, the hospital authorities are in fact liable for breach of duty in this case by its members of staff, simply because they didn't monitor the patients as required by their policy, and that every medical practitioner owes a duty of care to his patient to take all due care, caution, and diligence in treatment. I'm coming to this conclusion because the court has ordered the hospital to pay 54 million Kenyan shillings, because they have actually requested 500 million Kenyan shillings, but the court also had to consider the hospital. The hospital said that we are going to go out of business if this demand continues, and they have appealed. That was the final, settlement. But that is still a huge amount of money. You can avoid that one by just, introducing, whether you have a facility or clinic or anything, introducing medical litigation prevention, policies by training all your staff about. This is another important case. It has affected, actually, this one was between Aga Khan Hospital and a patient who was given contraceptive. And what we are learning here is that if you tell a patient this is the treatment and it's going to work 100%, if that 100% actually goes wrong and there's some complication, the patient will take us to task. That confidence of telling every treatment you give them, it is 100% effective or working. What has happened that this patient actually went to Aga Khan clinic for contraceptive. She inquired which one is the best. She was told Implanon is the best. She inquired how effective it is. She was not given, I'm not sure the documentation, but the patient claimed that she was told it is effective. And that's the word the court used, effective, because they will interpret every word you use in your documentation. After 1 month, the lady found out that she is pregnant. She actually went to court and claimed that because of the failure of the device and because of the unwanted subsequent pregnancy, the hospital has committed negligence. She claimed that she suffered emotional pain, distress, psychological damage, physical incapacity, financial, because she was not planning. Actually, she didn't plan for this pregnancy. She has closed that chapter of deliveries and pregnancy. As an expert in that field, she has consulted this hospital, and she was actually, for her, her claim was not that the contraceptive has failed. That's not what she's claiming. Her claim is actually premised that she was told this device, the implant is 100% effective. And that's why she went to court. And she has claimed that she needs upkeep for this child before he is even born until he is 18 years. Lucky enough, the hospital, they have demanded more than 200 million, but the court actually again had to consider that this is a hospital. 200 million is really out of reach of many institutions, and it's not going to happen. So she was awarded 4.3 million by the court calculation, and they calculated whatever the child needs, including school and all these things, until this child reached 18 years. But just imagine, as a doctor, you deliver your services, and out of that services, you have a child you have to raise for 18 years. You are not related biologically, but because out of your practice. And these are some things actually as doctors we can avoid by explaining to patients the success rate of every treatment. Yes, this appendicitis, it will relieve your symptoms. The chances of you going home is more than 90%, but there's 10% chance that you can get complications, anesthetic complications, bleeding, infection, emboli, and so on and so on. And you document all of that. Documentation saves us a lot of things. Having said that, these are just, the background of why medical negligence laws are very important for us doctors to understand, and actually to even learn in medical school, because medical law is going to affect us in the next few years, how we practice medicine. In the event medical negligence, claim ends up in court, there are three ways the courts actually will deal with it. The first one is that it will be left as a civil case. Civil case means that the patient will claim a tort. Tort means wrong done against the patient. The patient can claim that I was wronged by this hospital by injuring me when I came for treatment. Or contract. The patient can claim that I had a contract with this doctor. The contract arises from where? Doctor-patient relationship. Immediately a patient enters your premise, there is doctor-patient relationship. In rare cases, this case actually may end up in the desk of Director of Public Prosecution, but that's very rare. It has never happened in Kenya, apart from one in 2018, Dr. Charles Odiambo Cheng versus Republic, where a patient was done cesarean section and we couldn't trace the informed consent. The patient died for some reason. And it went to court. It went to the DCI. It went to the Director of Public Prosecution police case. And the lawyers have asked him, okay, yeah, it was maybe she was supposed to die, but where is the consent? There was no consent. The doctor says they have signed, they cannot trace. The court said that as long as there's no consent, this is not a civil case, it is an assault, actually murder. That's what they said. That patient was murdered, but he has appealed at the Court of Appeal, and it was reversed, and it was turned back to the court, civil courts. But in some cases, our case might end up in disciplinary, and that is actually the mildest form of, issue. For example, the hospital might, constitute a group of doctors and, the managers, and decide what to do with our case, whether a wrong was committed against it. Or sometimes it can end up in the medical board, whereby the medical board can order you for, many of us, we know that.
I've not renewed it.
Huh? Sorry? So this is very important principle in law, but it is actually creeping into medical law now. Because this principle is called res ipsa loquitur. It is a Latin word meaning that the thing speaks for itself. Sometimes when the injury the patient is claiming is very obvious, even to the judge, to the court, to everybody, the court can say that we don't even need to understand how things have happened. This patient went to this hospital for amputation of the right leg, but he came out with amputation of the left leg. So the court uses this principle called res ipsa loquitur, means that the thing speaks for itself, even if you defend yourself. And it actually goes back to a case decided in 1951 in UK, Cassidy vs. Ministry of Health. A patient went in actually for an operation to sort out, issues with two of his fingers, numbness. And he came out with actually 4 fingers which are numb. And the court was actually surprised that the patient, what happened? Because he went for, at least he should have come out with only 2 fingers numb. If he went in with 2 fingers numb, he should have. But in short, this principle says the court sometimes can say that we don't care what has happened. This patient actually went for this procedure, but he ended up with this other procedure, which was not necessary. Let's come to briefly to the definition of medical negligence. We all know an act or omission by a medical professional that deviates from the accepted standard of care. That is the basic definition of medical negligence. An act or omission happened in a hospital, deviated from what even the hospital has set for themselves as a policy. For example, if you fail to act on time in an emergency situation, that is a medical negligence according to the court's interpretation. For every medical negligence case, there are 4 limbs, which must be proven by the claimant, this time around by the patient. If a patient says that I have been injured by this hospital and I'm claiming for damages in terms of money based on medical negligence, they must prove that they had any relationship with the doctor. There was a duty of care. They must prove that there was a breach of that duty of care. They must prove that there was an injury. There was an injury. Not injury from other sources, injury because of the breach of the duty. And then there is a resulting damage. The general negligence actually, usually, general negligence, actually negligence doesn't only occur in medical practice, it occurs in traffic, it occurs in insurance, it occurs in land, it occurs in engineering, the civil engineering. So the general, definition of negligence, it goes back to when a person's conduct, that's what they say, a person's conduct falls below the standard of a behavior established by law for the protection of others against unreasonable risk of harm. Because everybody is supposed to act in a certain way. Whether you are driving somewhere, there are certain reasonable, behavior which you are supposed to drive. If a person actually has acted, a person has acted negligently, if they actually depart from that conduct expected of a reasonable person. The question is that who is a reasonable person? Reasonable person, the court actually uses the terminology reasonable. Who is a reasonable person? When someone's conduct falls below the standards established by law for the protection of others against unreasonable risk of harm. Usually courts use this principle of reasonable person to actually test every person who is in any profession, whether that person has committed a civil injury or not. Usually the courts will not accept if an injury has occurred because of your profession, that it was a mistake, it was a poor judgment, I came late, misconception, I didn't understand very well the history, or we miscalculated. That one is actually, we should not even go there with those. This reasonable person is just, hypothetical, but it's just imaginary. It's not really an existing person. But the courts actually use this reasonable person as somebody who approaches actually any situation with the appropriate amount of caution and then sensibly takes action. And that's what the courts actually tell us that doctors must take in every patient we approach with the caution they deserve, and we act accordingly. The most important, actually, one of the most important is standard of care for any profession. All professions, they have a standard of care. Lawyers, they have their own standard of care. Engineers, they have their own standard of care. The standard of care is a legal junction that's applied to determine if an individual should be held accountable and responsible for causing harm to others. The standard of care exists when professionals or organizations, or even companies or hospitals, offer services. Immediately you open a hospital, and that hospital opens its gate to the public, then the standard of care actually has been established, just the same way doctor-patient relationship has been established. And the court expects us, that we go by our standard of care. If a company or hospital or professional actually breaches the applicable standard of care, they are applicable, their policy. Every hospital has its own policy. The courts will ask you, okay, this has happened, the claim from this patient, do you have a policy on this? For example, there's a dispute, for example, on anesthesia. And the court will ask you, do you have policy on anesthesia, outpatient? Do you have a policy on outpatient anesthesia? Do you have a policy on light sedation for MRI? And that's why many hospitals, including Aga Khan, they have policy for every procedures and for every events. And they train their staff on all these policies, The standard of care is different in medical practice. Doctors usually in courts, they hold us, to a higher professional standard, They expect us to act, professional higher than any other profession because we are dealing with life, So the healthcare providers' actions or inactions are judged based on what a reasonable, competent provider with the same level of training would have done under similar. If you are a surgeon, and you have operated on a patient for appendicitis, the court actually will inquire how are surgeons in similar circumstances in Kakamega or Nairobi or even in the UK in appendicitis situation, how do they operate? And if you have deviated from that, then you have broken the standard of care and you have breached the contract. Then under the standard of care is the duty of care. What is duty of care? The general definition of duty of care is that a requirement that a person acts towards others and the public with watchfulness, attention, caution, and with responsibility. That is duty of care. And how do we translate this one in medical practice? We translate this one in medical practice, the duty to provide care at the level reasonably expected of any competent doctor, physician, or surgeon, or any other healthcare provider. If we say that I'm a surgeon, then this surgeon is expected to act towards his patient like any other surgeon around the world. There's no excuse. I've gotten a less training. I've trained in this university. Surgeon, all of them, they are a physician or even MOs. Doctors and hospitals are actually expected to provide treatment with knowledge and skill. at their command. And they're actually expected not to harm patients through lack of knowledge. That's why training, medical practice is one of few professions which has one of the most, training in terms of CMEs. Every week, CMEs, sometimes 3 CMEs, 4 CMEs. The court will not accept that I did not know that COVID-19 came 2019 and I don't understand how the pathophysiology. It's expected you to understand through CME. They're also expected to avoid harm through carelessness, recklessness, or through careless attitude of our staff. And that's why training of our staff routinely, drills. MI is coming tomorrow. We might expect MI tomorrow. If actually drill, some hospitals, they have drill for MI, even if there's no real MI, but they have stroke, so that they actually act according to what they are expected, according to the duty of care and the standard of care. Even when a doctor cannot save a patient, he is still expected to use his skill and knowledge in the most appropriate manner, and always keeping in mind the best interest of the patient. With the understanding that the patient's right to receive optimal care is a civil and human right. Because if you end up in courts will tell you that what you are giving, the service you are giving to this patient, although they are paying, it is their human right, and you have actually violated their human right. So based on the duty of care, the court usually subclassify the negligence actually according to the courts. They have their own negligence classification. It could be active negligence, collateral, but the most important is gross negligence and criminal negligence and reckless negligence. That's what usually happens in Kenya. The court will listen to what has happened. They will then classify, was it criminal negligence, gross negligence, or reckless negligence. For example, if you do an invasive procedure on a patient without informed consent, criminal negligence actually, unless we can defend ourselves. Then we are still under duty of care. Sometimes it's created by a natural law. We don't have to create a duty of care. If you are a doctor and you are in a plane and a patient goes into cardiac arrest and you keep quiet intentionally, and they realize, that patient, that you were there, somebody can take us to task under the natural law principle that you were supposed to act in this situation for this patient, but you didn't do anything. So, every argument in Kenya based on law has its own legal basis, and duty of care is not different. It has its own legal basis. In 1932, a lady by the name Mrs. May Donoghue, she bought a bottle of beer, and once she finished that beer, she realized that there was a snail sitting down there in the bottle. She became ill, and she took the manufacturer of that beer to court. And the court's conclusion was that the lady was owed a duty of care of due diligence by the manufacturer. This one applies to us, doctors. The patient was owed a due diligence before the procedure or treatment was taken. And that's why it's important for us. The House of Lords, which were deciding the case, they reasoned that it was reasonably foreseeable that failure to ensure their product safety would lead to harm to customers. In other words, it was the manufacturer's responsibility to foresee that whatever they produce could harm customers, and they should have actually modified their actions, their processes, so that that doesn't happen. Hospitals are also required to foresee gaps in their systems that would harm patients and rectify such gaps before actual harm occurs. Duty of care, generally, doctors' duty of care is very clear to many of us. If the moment you admit a patient, there's a doctor-patient relationship, and the duty of care of what treatment the patient should get and how that patient, it's just on our responsibility. If that patient is being managed by several doctors, the most senior doctors, specifically the admitting doctor, the consultant, it is responsibility. A breach of any of these duties may give rise to a cause of action of negligence, and the patient may recover damage from the doctor. But the duty of care, actually, it's a lot. It is widespread. It can affect every aspect of our profession, every aspect of our profession. For example, it includes taking proper history, keeping your record is proper, proper diagnosis, proper differential, diagnosis, timely referral if you cannot really manage this patient, consulting with other doctors, reviewing the abnormal results on time and acting on them, explanation to patient. About 10% actually to 15% of court cases, which patient take doctors to court, is because of the patient has not understood, what they are treating. And informed consent is really very important. So, if you are an employer, let's say you have a hospital and you have employed several doctors and a nurse and all these things, you cannot absolve yourself of blame if your employees have committed a fault or mistake, and that one has caused an injury to a patient. And this one actually comes through the principle of something called vicarious liability. I need to go a bit faster because I've explained vicarious liability. Vicarious liability is that it means I have a clinic in this hospital. I have this clinic and I have employed, several people, including doctors and nurses. If their mistake injures a patient, the person to be sued is the owner of the hospital, unless the owner of the hospital can prove why they cannot be sued. And that comes under a principle called res bodit superior. And this is a legal doctrine that holds an employer or principal legally responsible for the actions or inactions of the employees or agent, if such actions or inactions occurred within the scope of their employment. However, employees themselves cannot really blame their employer if they acted in a certain manner. For example, if this doctor works for this hospital, but he came when he's not on duty, for example, there's a rota, isn't it? And he has done a procedure within the hospital without following the proper hospital guideline, and he was not on duty, and he has not registered the patient in the system, and the patient was injured because of that, the hospital will not be sued. The person they are going to sue is that doctor who has, gone on a frolic on his own, means he has actually done outside the hospital procedures, outside the timing of the hospital, and so on and so on. Then the other important thing is breach of duty. We have talked about the standard of care. We have talked about duty of care, breach of duty. If a doctor actually has been accused of a breach of standard or duty of care, there must be a breach of that duty for a patient to recover. If a reasonable person fails to act reasonably, that's what the court say, given their duty of care, they will be found to have breached that of duty of care. If you are a professional practicing your trade, the court will judge you against another professional in similar practice. If you are an anesthesiologist, have you done what an anesthesiologist is supposed to be doing? Pre-anesthetic assessment, post-anesthetic, monitoring during patient education of patients, explaining to them, all these things. If a professional guides, actually, if a professional guideline exists now, and this is what I was saying, that the courts will ask for from a hospital, do you have a guideline on this? can you give us your guideline, your policy on this? We need to read. And the court actually will judge you against that policy, your own policy. And that's why if we have a policy, we follow our policy. If we don't have it, we create one. Specifically, if we are, owners of hospitals and even clinics and doctors. Breach of duty has occurred when a professional's conduct fails to meet the applicable rules of standard of care in that profession. If you are a surgeon, I was saying this one earlier, and you have operated on appendicitis, the court will actually cross-check how another surgeon of similar experience and training have performed. Expert witness, we have seen an expert witness earlier. It's very important for us to understand this Bolam test. In medical practice, courts actually use something called the Bolam test to determine whether a healthcare provider has breached duty of care or not. And Bolam test actually originates from a 1957. The reason why I'm quoting this one, these are called precedents, UK precedents. UK and Kenya, they have relationship. 90% of Kenyan laws actually have origin in UK laws through colonial history, because they have imported their laws. And Kenyan laws actually use the Bolam test now, this case law, to tie or release doctors when they are accused in court. And the case originates from Bolam, a gentleman called Bolam versus Friend Hospital Management in 1950. Okay, Bolam actually was undergoing a procedure called electroconvulsive therapy. I don't know if it's done these days. He had a depression, I think. He was not given muscle relaxants or something to calm him down. He sustained a scapular fracture. He brought an action, medical negligence action, actually, on the basis that the hospital actually breached duty of care because he was not given muscle relaxant. Now we understand duty of care, how it's coming in. This guy is saying that he has breached the duty of care because other hospitals, when they are giving this electroconvulsive therapy, they sedate their patient, but he has not sedated me, and I fractured there. The House of Commons, UK, invited actually two groups of expert witnesses. We have seen our own expert witness earlier. One group for the claimant, that's the patient, another group for the defendant. The two experts actually differ in this situation, whether there was a need or not to sedate the patient. The expert witness for the claimant, that's the patient, said that there was a need. He even quoted a textbook. The expert witness for the hospital said that there was no need because the patient, actually the sedation could have caused more problem. After listening to both sides, the court actually made a conclusion. And this is a very famous conclusion quoted by every court in Kenya as long as this case is a medical negligence case. The court said that a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that art. In other words, if you are a gynecologist and there was a perforation of a bladder and a medical negligence claim is brought against you, you will invite yourself other gynecologists to be your medical witness. And the patient will also invite other gynecologists. I don't know if that's possible these days in Kenya. It's a bit tricky. The court's conclusion has become to be known as the Bolam test in medical negligence around the world. It's present. Kenyan courts actually, they use the Bolam test to determine if there's a medical negligence or not. They use this theoretical test to determine whether an action of medic are in line with the practice of other medics in the same specialty. However, we should not celebrate because this Bolam test looks like it is supporting doctors. It is on our side. There's another case called Belitho versus City and Hackney Health Authority 1996. It is way after the Bolam case was decided. 2 years old, was taken to the emergency unit. He had a crew, he had difficulty in breathing. He was rushed to a hospital They waited for the doctor. The doctor didn't come. He went into respiratory arrest and died. The mother went to the court and sued the hospital. She argued that Belito, that's her son, should have lived if he were intubated. The hospital says, yes, there was a breach of duty. However, that breach of duty has not resulted of the death of the patient. The patient would have died anyway, whether we intubate or not. The hospital lawyers relied what? On the Bolam test, saying that if a doctor has acted reasonably, and there are other doctors who are supporting him in this, who are expert in that field, then the doctor is not guilty of, it's not liable of anything. The court actually concluded that a defendant, that's now the hospital or doctors, cannot escape liability by saying that the damage would have occurred in any event. In other words, these days in Kenya, Bolam test, which actually helps doctors, courts are very hesitant to accept the Bolam test. These days, the courts are using the Belito case, saying that a doctor must actually act according to to his training. Finally, for the cases, there's one final case called Montgomery versus Lanchka Health Board, which also says that if a doctor is performing a procedure and that procedure is risk, that doctor must inform the patient about the risk. That is the only thing they're asking. This is the court. You cannot go scot-free by claiming that I have operated on this patient and I've done the operation according to my training and according to the acceptable procedures within Kenya. No, the court will ask you that you have done the procedure, but have you informed the patient that there's 20% chance of death on table? And have you documented that and signed? Then the most important again is that you cannot really rely on a Bolam test these days. This one we have just discussed, and I need to rush to another point. So documentation is very important. Testimonies are also very important. That documentation for a patient to go to court, it must show that the patient actually was being treated by this doctor. There must be evidence that the patient was under this doctor. The patient actually submitted himself for examination and investigation. Treatment was provided and treatment was going on when the malpractice occurred. That's one, actually, you can say that there was a doctor-patient relationship and you can go to court. We have seen duty of care. We have seen breach of duty of care. This is injury caused by the duty of care. A patient must prove that an injury has occurred as a result of the breach of that of duty. For example, if the patient was injured, but there was no breach of duty, there's no case to answer for the doctor. The court will automatically dismiss. If the claimant has succeeded in all other limbs, she is entitled to damage. The basic principle in damage is that the claimant should be put back. The claimant, who is now the claimant, the patient, should be put back to the position he was before the negligent occurred. If the patient actually, this is a very important principle. When the patient is claiming an injury, and he has succeeded in all the limbs we have discussed, the court will actually would want this patient to be put where he was before the injury. What was he doing? Was he a musical, person? He was a singer? Was he how much was he earning? Where was he staying? Was he a student? How much are there people who are depending on him? And actually, when they are calculating that injury money, they use all that. If you are not employed, and you are staying with your parents, the court will not accept to claim of loss of money in terms of salary, because there's no evidence that you were working even before you were injured. And that's how they do the calculations. The calculations are actually done under fair and reasonable compensation for the injuries suffered. For example, finger loss, profession claim. If you're a musician and you have lost a finger, you understand that you cannot, even if you are healthy, no other issue, but the finger is lost, then they will actually make a lot of money from that. For pain and suffering, for future, losses, expenses incurred, and, loss of amenity. Why do patients sue? Actually, you will be surprised. Some of the reasons why patients sue is actually it's just communication. It's just communication. Sometimes if we talk to our patients and we inform about what has happened and we update them every second and minute of what's going on, rarely patients take us to court, And these are the reasons why patients sue. Inadequate follow-up, prescription errors. Defensive medicine, you have ordered for a lot of MRIs and all these things, and you have not explained to the patient, and failure to communicate and all these things. These are the reasons. How do we prevent? Documentation is number one, shield against medical negligence. And when you are documenting, let the patient actually also understand what you have documented. Because if you document your own things and the patient saying different things, sometimes it's a bit difficult. Courts, for some reason, they like, siding with patients. It has to be eligible, very crucial. Patient education is also very important. Be, empathetic with our patients. Simple apology actually helps a lot. Sometimes it's difficult, when a patient died by mistake, and how do you apologize? That's all, it's a very controversial area. Consult with other doctors. Never blame other doctors for a mistake that has happened, because the patient is accusing you and you think that you are deflecting that blame. You are giving a chance for the patient to sue more doctors. He will sue you. You have given him another person to sue. So he will sue everybody. So if you are in trouble, come out of that situation yourself and alone without blaming anybody. Hospital records are very important. Policies are very important, but also adhering to those policies are also equally important. Train your staff. Train them on medical negligence. Many hospitals are actually having in-hospital lawyers, especially big hospitals. If you go to Aga Khan, Bashir Hospital, even Kenyatta, I'm sure even Moi, MTRH, they're lawyers who actually develop policies. And don't forget the 4 C's in medical practice, actually, to minimize litigation: completeness, correctness, clarity, courtesy, and consideration. We are about to get that. And then you avoid taking something legal jargon, they call it pot shots at other doctors. Don't document other doctors' shortcomings in the file. That is a no-no. Don't talk bad about other doctors to patients. That's a no-no, because the patient will sue all of you. You who has told the patient about the other doctor plus yourself. In the eyes of court, actually, malalignment of other doctors will not serve you in court. It will only give patients more individuals to sue, including yourself, the whistleblower. So the challenge actually in medical practice in relation to medical negligence, there are many. Medical litigation cases are rising in Kenya, especially in private sector. Hospital, medical fraternity actually are lagging behind in terms of prevention of medical legal litigations, because the literature we are using in medical law is actually coming from lawyers. And actually this should change, because as doctors, we must understand medical law and write literature the same way we have written books in medicine. We must write books in medical law, because courts rely on these books. They rely on this literature. They rely on these publications of what is standard of care, what is of duty of care, what's breach of care, and calculation of damages. Medical institutions actually are not investing adequately about risk management of their practice, poor medical record keeping, and inadequate training of staff. But there are also opportunities, We need to incorporate medical legal content into undergraduate medical training. In medical school, we are taught enough of ethics. the principles of ethics. But this time around, maybe there's an opportunity to teach actually medical law itself, how to avoid, prevent limbs of medical law, confidentiality, informed consent, all these things, so that when we come out as doctors, we are well prepared for the world of medical negligence. Then organize periodic medical legal training, very important for colleagues and everybody, so that we understand the contemporary medical legal issues in Kenya, so that you are not, the moment you go to medical actually legal litigation and you end up in court, coming out is very difficult. I've seen many colleagues who were there. Psychologically, it affects you. Credibility-wise, it affects you. Media is involved. They will splash your name on there. I don't know where, social media, all these things, sometimes suspension, you end up in. So the best, it is cheaper. It is cheaper to avoid medical negligence. It's very difficult to face medical negligence in court. And then we need to explore alternative, dispute resolution out of court settlement is much cheaper. There are some guys who are specializing in this, called medical legal out of court. Actually, they are called medical legal mediators. And instead of going to court, patients actually end up in there, then the doctor, the hospital, this. But this one, again, it ends up in money. Because even if you don't, as a doctor, you have two options. If you feel like you have not committed anything, you end up in court. But if there was an injury and you feel like, maybe there was a shortcoming on your side, then the arbitration and mediation is okay. That one ends up in settlement, and that settlement in 90% is money. Thank you very much for your attention. I've taken about 55 minutes, and these are the bibliography. Back to the moderator. Thank you very much.
Thank you, Dr. Bashir. Maybe now we can welcome the questions. Let me see on the chat box the questions that we have. Anyway, most of the people are just appreciating your work. A question by Serem to everyone. Is it possible to prove medical negligence in an out-of-hospital setting, like an emergency situation in a restaurant, for example? I don't know, Doc, if it's clear. Is it possible to prove medical negligence in an out-of-hospital setting, like an emergency situation, for instance, in a restaurant?
Thank you very much, actually, Doc, for that question. In emergency situation, when you are actually in a restaurant with your family in a picnic, generally, usually, there's no relationship you have with the patient. The only thing negligence you can commit is patients in cardiac arrest and you watch them. That is if the patient and the relatives identify you as a doctor. However, there's no negligence which can result out of that event which you have no business with, and you have actually provided humanitarian assistance. And you have done CPR, and you have asked the relative to call ambulance, and you have done everything you could do in that situation. Even if the patient dies, you are not negligent. The only way you can be negligent is that if you observe the patients and they actually go into cardiac arrest, the only thing you can do is, as if you are a doctor, do what the doctor actually out of hospital cardiac arrest. Yeah? CPR, call ambulance, no negligence for you. And we will not even reach the point of proving, because the court will say that this doctor was in this restaurant, this guy went to cardiac, is their relationship, is their doctor-patient relationship. He's not his doctor, he has done what he could. That's actually what I'm thinking. Dr. Kalib, have you heard me? It seems Dr. Kalib is not with us. So there are other questions.
Hello, Dr. Kalib, can you hear me?
Yeah, now
Hello.
I can hear you.
Can you hear me now? Yes, I'm saying you answered the question very clearly. Now the next question is by Sheila. Doc, can you hear me?
Yes, Doc.
Yeah. Is it mandatory to have a law degree in addition to MBCHP before being allowed to practice medical legal law in Kenya?
So, law and medicine, they are very divergent disciplines which are interconnected. Each of them requires licensing. For you to practice medicine in Kenya, you must be licensed by the body, the board. For you to practice law, whatever it is, whether it is medical legal or any other law, because you can specialize any branch of law. There's contract law, there's petroleum law, there's international law. So in this case, medical law, if you are to practice, the first thing is that you must have a degree in law. The second is that you must register with Kenya Law Society of Kenya. That is the only way. Yes. So in short is that if you want to practice medical law, you must have a degree in law. Thank you.
Thank you, Daktari. Our next question by Dr. Njuguna is asking, does a hospital reserve the right to treat a patient or decline treatment for a patient? For example, a patient who has sued the hospital before, even if unsuccessfully, do you have the right to decline service to that patient, especially if maybe in an emergency situation or just a normal, yeah.
So in an emergency situation, if a guy who sued you like 2 months ago brought in with a left-sided weakness and a massive stroke, doctor-patient relationship exists by the principle of natural law. This was not created by the hospital. This doctor-patient relationship was not created by the patient or by the doctor or by the hospital, but it was created by the circumstance. You treat that patient, you stabilize, and you transfer to another hospital because you say that there's conflict of interest, but you cannot abandon them there. And actually, you must identify another hospital. If you are in MTRH, you must call, these other hospitals within Eldoret and send him there. But you can also accept to treat. So in other words, can I deny to treat him? No, you have to treat him. If you don't want to treat him, you open record for them, register them, then transfer to another doctor.
Thank you. The next question, Doctor, is for a doctor in training. This has been asked by Dr. Awor Ondeng. For a doctor in training, for example, a resident or a registrar, how does it work? For example, a surgical resident, can he be held liable in a surgical case? I think he's touching on the issue of employer responsibility, resident superior. Maybe, Doc, you can touch on that.
If I understood, if you are a registrar, number one, you have a license. You have a license with the board. If you commit any mistake based on your training, specifically the standard of care according to, because everything has its own standard of care. The standard of care for nephrology, standard of care of a medical officer, standard of care of surgeon. So if you are a registrar or MO, there's a standard of care. And if this patient, you have seen that he needs a referral, you need to refer. And if you don't refer on time, they will blame you. You will end up being sued. So in other words, everybody has got its own limit and capacity within that practice. If you have treated this patient, was it within your limit and capacity? If you have gone beyond your limit, you will be blamed. But if you have referred, then you are absolved.
Thank you, Dr. There was another question by Kennedy Baraza. Sorry, I had dropped off and then I think I lost the question, but I had read the question. He was giving a scenario whereby there was a professor in UK, I think, who lost his license because of prescribing a certain medication to a relative. And I think it's a very common norm for us doctors, especially doing such services to our friends and relatives, prescriptions and whatnot. Maybe, Dr. you can talk on that. I don't know if you have understood the question.
Yeah, understood. If you treat your brother and you have given him overdose of morphine and he dies, for a claim to arise, there must be a claimant. Somebody must go to court. Somebody must go to court and sue. So if your brother has, or the relatives who are remaining, they have not sued you, and then there's no, there's something called locus standa in court. In court says that, was there a complainant? If somebody has died, you know, there was no complainant. But also, you know, this thing sometimes also can come criminal. If this information has been spilled to the media and everybody, the director of the public prosecution can say that this doctor has given this medication and he has killed this person, you know, negligently. So even if there's no, even if there's no complainant from the relatives, but the government, the state is the complainant. So it's a bit very complex, you know, question. It depends on the scenario. In short, if you are saying that if you have given medication to your relative and they were injured, if they have not complained, then nothing will go. But if it is a very serious issue, like somebody has died because of that, there are two ways. Maybe the family will come together and they just leave it there. But if the government, you know, gets hold of it, the government has the right to take you to court.
Thank you, Daktari. Maybe a question from my side. Daktari, let's say we have situations whereby patients are normally brought to the hospital and then relatives run away and you don't have any contact about the patient. Case in point, maybe you can get a patient who is confused, maybe you are has maybe pulmonary effusion or a pleural effusion, sorry, or maybe you need to do a lumbar puncture or let's say a procedure that you want to do, and you don't have any, let's say, guardian or caregiver to maybe get the consent from. How do you maneuver through, let's say, such a situation for you to avoid maybe litigations to arise in future?
Doc, if the procedure is emergency, usually we don't need informed consent. If it's an emergency procedure, this person, they're no relatives, we don't do emergency dialysis, they're going to die, we don't need their consent. If it's not a medical procedure, you look for consent. That consent can come from their relatives. If there are no relatives, we are on the hospital, then the most senior doctor within the hospital acts on behalf of these patients. If they are adults and awake and they are fully conscious, it is them to sign. If that's not possible, the hospital CEO, the surgeon in the hospital, they can decide to sign. Or you can get a court order to do this procedure. In Kenya, getting court order is not possible. In UK, it's possible. So you sign for them. So it depends on the situation, Doc. Thank you.
Thank you, Daktari. Any other person with a burning question? Maybe you can even raise your hand or just unmute yourself and speak.
Chair, I have a question.
Yes, Timothy, please go ahead.
Okay, my question is to Dr. Bashir. As a follow-up question to the first question he answered, where he said it's not possible to prove medical negligence in an out-of-hospital setting because in that situation there is no contract between the there's no breach of care because there's no contract between the patient and the doctor. So my question is, what if in a situation where a patient comes to your clinic for a procedure which you which is not in which you're not supposed to do? Maybe like as a physician, a patient comes to your clinic with an emergency obstetric condition like APH, and you proceed and do the procedure, and after the patient complicates, and you're supposed you attempt to manage the condition, maybe requiring something like TAH, and afterwards the outcome maybe is not good. And then the patient decides to sue you afterwards. In that situation, is it better to just refer the patient even if you know this patient will not be able to make it, or you go ahead and attempt the procedure and you document that there was you did it in the best interest of the patient?
Doc, thank you very much. It's a bit complex, actually, scenario. For the simple reason is that if you're a physician and a lady who is delivering comes to your door, you know, usually now the duty of care is not there. For you, the best you can do is stabilize the patient and refer to the next doctor or a nurse who can do that. Or if you can do it yourself, you can do it. However, the issue is that, many people deliver, and even in buses and all these things, and they are assisted by good Samaritans. But the main thing is that if you have done, an emergency situation and it has gone wrong, and you are not trained to do that, it's a bit tricky, doc. It's a bit tricky, unless it is cardiac arrest, which you have to do the normal thing. All other things, you must refer to the right people. Or admit the patient to your facility and invite a colleague. Actually, that's even much better, because you are a clinic, you have maybe a bed. Or look for an ambulance. So that's what I'm thinking. If you practice outside your, profession, and something happens, this patient, although they came to you, unless it is cardiac arrest, which the laws are different. Otherwise, it's a referral is very. If it's a referable patient, yeah. Thank you.
Thank you, Daktari, and thank you, Dr. Karone. Dr. Karone shares about the UK. So she says in the UK, the GMC investigates all hospital deaths and can suspend your license even if the family is not suing. So a lot of defense medicine is practiced, very expensive to the NHS. I think in the near future, probably even Kenya, this is where we are heading. With the literacy level and also social media and whatnot, patients are becoming more educated. So it has come at the right time, Dr. You are this discussion that you dissecting clearly. Any other question, or anyone with a burning question, you can just unmute yourself. I think it's now 11 minutes to 8. You can just wrap it up.
Maybe my question was to Dr. Bashir. For facilities like level 6, which we know is the highest level within the country, what happens in cases where maybe the patient needs ICU care, and you find that in that particular level 6, the bed capacity is full, and the patient is unable maybe to afford the private facilities because of the deposit that they normally require? Who bears the burden of care to that patient in such a scenario?
Doc, thank you very much. Actually, this is very practical, and I've even seen it before. In a situation like this, God forbid if a patient dies because there was no ICU, the court will ask you, did the patient die because of lack of ICU, or he was killed, he died because of his condition? The second question the court will ask you is that, even if he was taken to ICU, what was his prognosis? Was he going to survive? What were the underlying conditions? Was he the gentleman who was playing football and he was hit on the chest? He went into cardiac arrest, very young, 20. That guy must get it in ICU bed in anywhere, whether it's level 6 or level 7. Yeah? But the gentleman who is 90 years, with respiratory distress, renal failure, the courts are lenient with doctors, because the doctors can claim that, number one, there was no bed. Number two, even if there were a bed, his condition wouldn't have been any better. So, Doc, in the court, in this situation, there are claims and counterclaims, and eventually it depends on what the judge believes, Thank you.
I now want to take this opportunity to invite Dr. Coach Matthew, maybe to say something. Daktari, karibu.
No, I don't have much. Thank you, Dr. Bashir. I think I've learned quite a bit, and probably we are going to request you one of these days to present in the School of Medicine Grand Round, so that many people can actually understand some of these things, because Kenya is increasingly becoming a litigious society, and it's good to be aware of some of these things. So thank you. I'm really impressed and happy by the presentation. I think the only thing I wanted to just add for the audience is we are going to use the new KMPDC system where we upload your names and board numbers, and the points will be automatically added to your portfolio. So for that, I think we are going to request all of you to supply us with your email addresses and board registration number. So normally the system needs board registration number, email address, and the name. For most of you, we have your names and we have your emails sometimes, but the thing we don't consistently have is your board numbers. So provide your board numbers, and then we will automatically upload, and then points will be automatically be added to your portfolio. So you don't have to input the tokens, and if you lose them, so it becomes easier for us. So otherwise, thank you, thank you, Dr. Bashir, for the excellent presentation.
Thank you.
Bashir, I am going to look for you. I buy when on Friday after we finish Eid. I'll look for you. I buy you coffee and I introduce you to some of my lawyer friends.
Thank you, Doc. Thank
Very
you.
nice. In fact, we were listening with another friend of mine who's a lawyer, and he was quite impressed and very happy to hear doctors talking about law. Thank you very much. Everyone have a happy Eid on Friday. I hope everyone has been fasting like all of us, and eating twice a day only, including Fidelio Mwangi and the rest. But thank you for the nice attendance and for the nice discussion.
Thank you, Daktari. I think without much further ado, maybe we can just wrap the presentation. And let me take this opportunity to thank Dr. Bashir for creating time. This is for the second presentation. But these are topics that are very important in our day-to-day activity. And with our continuous practice of medicine, I think we might be able to maybe use this information to help us maneuver through. Thank you, Daktari. And then also to thank the Octave fraternity for at least organizing this great session. And everyone, lastly, for attending and getting time. The next presentation soon. Thank you.
Thank you, Doc.